Okay, good morning or evening, the case may be. This is Mr. Max Chaudhary. This is the webinar I have periodically. I always have the kind of introduction, which is basically to say that this webinar is meant to be eventually in the public. So if you're not comfortable with your image or your issues, then you can, mute your microphone and pose the questions in the chat, and no longer have your face if that's the question. But people will come and go, and the purpose is to provide some general guidance for Canadian immigration and visa matters. And we always give a priority to people who show up. But at the same time, for the record, there was a number of questions which I'll read in and respond to, and then post those on social media. So if you don't want your visage or your voice on social media, you can still participate by posing the questions in the chat. So, but there's two live people here. So if anybody has a particular question who's here, they can pose it in the chat. That might be the order of operation, because like if there's like a bunch of people participating, then we'll just be talking over each other, and then I won't be able to digest the question, or I might be mixing up the questions. So with that in mind, I can keep the chat box open and receive the questions there. Oh yeah, that's a good question. So we try to with these various channels, it's pretty well most of the popular ones. So that would be Instagram, TikTok, sometimes LinkedIn, YouTube Shorts, right? These sorts of things.
Facebook too?
Yeah, Facebook too. Yeah, I think Facebook and Instagram. Yeah. So
what's the Facebook channel that I can follow?
I think it's Max.Chaudhary. I should know this. I mean, my Instagram is chaudhary.law, and like it seems to disseminate. So I want to I want to state sort of the general guidelines first. So because then I may answer sort of basic questions. So when we talk about what I suspect is the group here, which is permanent residency in 2026 in Canada, leading to Canadian citizenship in Canada.
Exactly.
Yeah. So that's this is the sort of fundamentals are that there's the express entry regime, and so that is the snappy term for the federal system for immigration, and then that is subdivided under federal skilled worker, which is basically people with foreign work experience outside of Canada. And there's Canada Experience Class, which is for people who have at least 1 year of Canadian work experience. Then there's federal skilled trades. So that's people with a licensure in things like plumbing, electrician, maybe bricklaying and things of that nature. That's the federal regime. And then there's the provincial streams. And the way the system there works is that the federal government allocates a certain amount of permanent resident spots under the 380,000 to each province. And then the province devises its own criteria for this. And that's the province subdivides it. The provinces assess entrepreneurs on the one hand, and they have their own skilled worker stream, some of which may include people with foreign work experience. And they have others which are job offer based. So that's the sort of overall structure for which I think is relevant for people who have outside of Canada work experience interested in immigrating to Canada. So if we sort of drill down a bit further from there, especially now in 2026, starting arguably from May 2024, where we do see something of an immigration backlash in Canada, stemming from the proliferation of too many study permit holders who, prior to 2024, between 2015 and 2024, had what looked like a relatively sure pathway to permanent residency because the pathway was based on simply having skilled Canadian experience, full stop. And what I mean is the distinction was that it did not have to be targeted in occupational demand, but rather just, well, if you had a skill set and Canadian work experience after graduating in a 2-year program in Canada at a post-secondary level, it was almost a sure thing. But too many people availed themselves of that, and that led to a flooding of Canada with too many international students. And I mean, you could see it online, you can Google that. So that the relevance of that comes in terms of what's happened since 2024, which is the federal express entry regime has started to have targeted draws. And their priorities under the targeted draws, broadly speaking, are occupations that there's a labor market shortage and French language speakers, because we have apparently there's a government consensus that we want to promote French speaking people outside the province of Quebec. So despite the fact that, I mean, there's some studies that show that those people may have difficulty economically integrating in Canada. I mean, from what I've gleaned, I don't know if that's actually true, but that's sort of the quasi-academic rumor. And then if we go to the, what are the targeted occupations? Typically, it's the occupations that Canada has failed to accommodate for, like physicians, because we didn't train enough physicians in Canada. And some of the allied healthcare professionals, such as the jobs that are really difficult, like nurse, personal support worker, not pharmacist, because I guess there are too many pharmacists in Canada, but a lot of those more difficult jobs. And then there's some niche jobs related to highly specialized data analytics. There was a time between beginning of 2024 until maybe June 2024 when a lot of IT jobs were being selected by the provinces. But now that market's bottomed out, I suppose artificial intelligence is sort of eating into that, getting into those, attacking those entry-level software jobs, essentially. So the landscape is politely saying we're only looking after what is our sort of short and medium-term economic needs. Now, I'm excluding, just for the sake of completeness, I'm excluding the other broad swath of immigration, like family class, which is sponsoring your spouse, which is always like an evergreen kind of thing, like a Canadian PR or a Canadian citizen sponsoring a spouse or common law partner. And we have a refugee program in Canada that's got a very robust due process system. I mean, you can't really avail yourself of it unless you somehow come to Canada. I mean, there's an overseas refugee process, but that's been paused again because, world events, and we don't have we have too many temporary residents in Canada. We don't know what to do with them. We don't have a pathway that was once very clear for them 2 years ago. So there's a bunch of temporary residents in Canada. There's a fear that they will be trying to use the in-Canada refugee system. There's been an increase in enforcement marked by the increase in funding for enforcement. So they give funding to the Canada Border Service Agency, which I guess is the Canadian equivalent of ICE, or I suppose, right? And they've amped up the deportations for this. So all of that is to say that immigration is, it's not, I wouldn't say it's not like amplified, but targeted to the very, very specific short and medium economic needs. So if we sort of talk about, again, just to anticipate some questions, what are the parameters here, then we can sort of start from the obvious, which is job offer, and then there's types of job offers. Now, these job offers have to be vetted by some credible authority. So the Canadian government does not have expertise necessarily in vetting these job offers. So sometimes they have these very niche programs targeting individual cities, small cities like Thunder Bay and I believe Sault Ste. Marie, and these small cities in the prairie provinces, which I forget the names of. They're so small. I mean, I don't know the names of them. I mean, I was born here, but they're targeting, um, they're delegating uh, what is the labor market need to these community business organizations in these small cities in Ontario and the Maritimes and the prairies and British Columbia. So they deem the need to be determined by these organizations in these small cities. And they say, and then they register with the municipality saying, I'm a legitimate business. And the municipality agrees. And then that's the way to get a certificate. And I've dealt with a client who had this offer in Thunder Bay. And these are like, I was kind of surprised. These were kind of like, well, I mean, this is not, it kind of equates with what I'm seeing. It was like a psychotherapist or some kind of psychological job. This young lady had a job offer in Thunder Bay, and she was going over the forms with me. So again, the whole fundamental aspect again is what is targeted for the labor market needs, in this case of a community. Now, I want to be comprehensive about that as well. So before this this sort of mushrooming of small towns being delegated to determine their labor market needs, there's the overall traditional federal process where the federal government has ESDC Canada, also known as Service Canada. They are tasked with assessing the genuineness of a job offer through this process and a Canadian employer has called a labor market impact assessment. You can Google it as LMIA, right? So LMIA is essentially the federal government's screening process to receive information from an employer, and the employer is saying in a form, and they pay a fee, and they say, I'm a jeweler, and I deal with unusual jewelry from South Asia or the Middle East. And I found a jeweler in Bangladesh. And I have a market where I repair this elaborate jewelry. And I've tried to advertise in 3 different venues of advertising for this type of jeweler. And I could not find this type of jeweler. And I need my business to expand to repair this jewelry. So ESDC Canada or Service Canada, they would review the arguments of the employer and they would ask for who looked for this job, what were the results of the online want ads on monster.com or LinkedIn. And they would say, oh, it looks like you made reasonable efforts to recruit a specialized jewelry repair person. It looks like you offered a job that was the median wage, so it would be attractive to people. It looks like you offered a job to First Nations. It looks like you could not train the person. It looks like you could not hire a person from the smaller, poorer provinces, such as the Maritimes. And then they would issue, okay, a labor market impact assessment that was positive. So that positive LMIA would go to the candidate who was living in, let's say, Bangladesh. They would apply for a work permit, and then the visa officer, probably in Singapore, would, or Chittagong, I don't recall, they would review the labor market impact assessment reviewed the candidate's work experience to see if the person did in fact have the experience, did in fact have the requisite amount of English or French, and then say, oh yeah, okay, looks like you get the job, and they would issue the work permit. And then prior to 2025, if the person was a certain age, they would accumulate 1 year of Canadian work experience. And then this goes back to the initial structure of what I said. Express entry, subcategory of express entry is CEC, Canada Experience Class. That person would have accumulated 1 year of work experience. Prior to 2025, they would get additional points, an additional 50 points if the employer says, I intend to keep this person on as an employee on a long-term basis. And if they were under 40 years old, and if they had fluent English, the extra 50 points would probably, after 1 or 2 years working, would be enough for the express entry point draw. So that's sort of the sort of the best case scenario. So what things to keep in mind now, going now to 2026, is that they canceled the extra 50 points for having a long-term job offer. You used to get 50 points for like a skilled job, or 200 points for an executive level job, like CEO, this sort of thing. That was to compensate for, executives who wanted to become CEO of a mid-size or Canadian company who were too old. So they would say, okay, well, you're going to be working as an executive. So to compensate for the loss of age, you'd get 200 points. Now it's gone as of 2025 and still gone. It may come back according to the meetings that we have, our sort of stakeholder meetings as members of the Canadian Bar Association with the Immigration Department. So this is all to say, again, the kind of rubric you have to keep in mind about is that it's targeted draws based on occupation. There's a lot of skepticism about the genuineness of the labor market impact assessment job offers in the past year or so. So it's even more difficult to recruit somebody outside of Canada. So those are sort of some of the sort of overarching things. And this may lead to some questions in the chat. Now that I've given like sort of a semi-comprehensive broad brushstroke view of immigrating to Canada as a skilled worker. So if I look at the questions now, I mean, you could start to pose the questions now. So when it talks about, there's C11. Okay, so this is the work. This is the work pathway. So this is a pathway to get a work permit. It's a policy. There's C10, which is when the employer intends to hire somebody with significant or very niche skills. Then there's C11. C11 is where somebody wants to run a business or partake in a business. So the idea is that the Canadian government, the sort of policy basis for C11 is that the Canadian government wants to make sure that if there is a business that is going to be created, or a business that is operating, but maybe the business owner is going to retire, that jobs will be either created in the case of a new business to be formed, or jobs will be maintained in the situation of a foreign national who wants to purchase a business. So if we look at what they're looking for, the question here is, does a C11 officer tasked with assessing the work permit look at the type of business franchise for this? I think the short answer is yes, but it's a holistic kind of assessment. So the sort of newer underlying preference for C11 is having some flexibility for the type of business if it can be integral to, let's say, a community. So a community, what they're thinking about is a smaller community outside the major cities like Toronto, Montreal, Calgary, Vancouver, Edmonton. because this ties into the sort of demographic issue where it's not uncommon that older people would be retiring in smaller towns and cities. So the Canadian government wants to maintain some degree of viability for these cities. So that ties into the type of franchise an officer might be more inclined to agree to. So if you think about what is the functioning aspect of a city, there's access to food, access to transport. So those things mean like grocery stores and automotive repair. I mean, that's just off the top of my head. There might be sort of niche things like, and this is where like a business plan with business research would have to be done. Like, maybe like a sort of, acupuncture, registered massage therapy kind of thing, dealing with underserved community. Maybe the demographics would be borne out in the business plan to show that it's viable to have a niche kind of business. They would do the research about the income level and the demographics of the community and saying, yeah, this type of business would make sense, this sort of thing. So that would sort of weigh or loom large in the mind of the officer in terms of the type of business. If we think about franchises in general, some franchises have a good reputation and some don't. Some have more financial requirements and then some don't. Another factor the officer would have is whether, if this is a new franchise, is it going to create two jobs, and does it have a good track record of having a good support of the franchisee? Some officers might have access to some research about which franchises are good and which franchises are not good and which treat their franchisees well, this sort of thing. Because the lens of the officer in that scenario is whether the business looks like it would be viable on a medium or long-term basis, and not just be simply a conduit or a vehicle to get immigration. There was a lot of abuse 30 years ago where the entrepreneur program was not that sophisticated. So people would buy a gift shop in a hotel and employ one or two people in the gift shop. And then they would get their PR. And then they would sell the gift shop to another entrepreneur. And they would use this and say, I have two employees. And then it was not doing anything. It was not creating any business. So that's an extreme example of that. So I hope I tackled sort of the context of that type of franchise question. And then there's a question, I think, related to the express entry point regime. Would the 50/200 points under express entry come back, right? And then there was a meeting in, I believe, early 2025, where they said it would come back. But there's not a lot of transparency with the Canadian government on immigration programs that affect foreign nationals, because the Canadian government is highly sensitive to the impact of immigration on their popularity. And because foreign nationals do not vote, my view is that if the labor market either organically wants a 200-point or 50-point bonus to attract long-term employees, then it will come back. That would be the assumption, right? And then a more generic question is, can you change your status from tourist to PR? Okay, so if I think about this in the sort of overall legislative structure, the classic straightforward example is if you are a tourist and let's say you're single and you marry a Canadian because you've lived in Canada for 6 months as a tourist, then you can both apply for permanent residency in Canada And then you can apply for what's called a spousal open work permit or common law, as the case may be. So that's the classic example where it's embedded in the policy that you could change your status from visitor to permanent resident without even leaving Canada. That's overall, I mean, that's a different category. That's not the economic category. That's the family class category. So if we drill down to what I think is sort of the crowd here, this is probably would-be economic or entrepreneur um, applicants. So in that scenario, changing from permanent resident, or sorry, from visitor to permanent resident while you're in Canada would be subject to a lot of restrictions. Aside from COVID, where it was very easy to change from worker to PR, the ways that would likely still subsist now in 2026 would be if you were working in a province, and the province, let's say, is Ontario, and they had Ontario has what's called, under its provincial nominee program, the employer job offer stream, where you might be already working for the employer, and then the employer has registered their business with the province of Ontario, saying, for example, they have a minimum of 5 employees and a gross income of $1 million if it's located in a big city. And then the province is satisfied it's a legitimate business. And then the employer says, yes, I want to retain this person. So the person, while already in an existing employer-employee relationship, would get a certificate of nomination, which is 600 points, and that would be plugged into the express entry regime. So that's one way they would do that. And there are analogous ways in the less populous provinces. I know if you think strategically, some of these provinces, they award people who studied in those provinces by studying and then graduating in those provinces. And if they work in those provinces, then in some cases they only need 6 months of work experience. I believe that might be Manitoba and some of the maritime provinces. But in terms of completing the pathway, even those people, they need that, basically what's called indeterminate job offer from that employer in that smaller province, despite the fact that they're only working for 6 months in that smaller province. So those are, in 2026, those are the types of ways that are viable for this. I touched upon the 200 points and the 50 points previously. That previously was a pathway, because that example I touched upon, which was the chief executive officer or chief financial officer working for like a large company. The company would offer them a job, and they would get 200 points to compensate for their age. But that regime is paused for now. So that's sort of the lay of the land right now. So, and there's a question related to taking over a franchise or some other business. I assume the question is, would that come under C11? I would say yes, if the argument is that you are going to maintain jobs that would no longer exist because the employer is no longer able or willing to run the business and has come to an agreement with you to purchase the business. And then in that scenario, you would apply for a C11 work permit. You would say the closing of the business and the transfer of the business would be, to be safe, you want to say like 100 days from now, because work permit processing times. Then the officer would want proof of the transfer of the business, and would want proof that as part of the terms and conditions of that business, that the employment would be maintained. And that would probably assuage the officer about taking over a business as opposed to establishing a business. So those are the the questions in the chat. There's a number of questions people posed to me in the past 30 days. I mean, if I don't see any, just for the sake of completeness and making content, I will address those questions on the assumption that those people will find their question posed on the social media. So a lot of these questions related to already filed applications. So, for example, one person filed under the Ontario Immigration Nominee Program, Foreign Worker Stream. So that's the program where they presented foreign worker experience outside of Canada and had a job offer by an employer in Ontario. In this case, this was for a nurse. And they filed this case themselves. And the requirements were that they needed to have 2 years of experience as a nurse, but they were issued what is called a procedural fairness letter in the middle of their permanent resident application. A procedural fairness letter is basically a letter issued to the client after their permanent resident case was filed, and it's a signal by the immigration officer saying, I want to give you due process by sending you this procedural fairness letter, and I'm going to give you 30 days to address this specific concern. The concern in this case was that at the time you received the nomination, you said you had 2 years of foreign worker experience and Canadian work experience, totaling at least 2 years, at the time of submitting the application. According to our records, the work experience outside of Canada doesn't look like it's comprehensive enough or adds up to 2 years of work experience. And as a courtesy, we will give you 30 days to respond to this. So in this situation, the idea is to review what you submitted for your work experience. And if the officer is not explicitly expressing the concern, then you have to determine what was it that looks ambiguous about your work experience. For example, is it ambiguous about the duties performed? Is it not clear about the remuneration? Is in some cases, not in this case, but in some cases, there's a poison pen letter. Or in some cases, the officer called the venue of employment and said, we have no idea who this person is. This person did not work as a nurse. In which case, you'd have to explain that some way or the other, either with the documents in the case of a sort of dearth of detail, or in the more sort of egregious case where the employer where you said you work says, I have no idea, then you'd have to get an affidavit of the employer saying, for example, the person who answered the phone was new, they didn't know who this person was, and they didn't have access to the records of when this person worked for us, etc. So that's sort of the sort of short-term strategic thinking you have to have in these cases where a permanent resident application was filed, but there's a concern being expressed about the genuineness or the comprehensiveness of the permanent residence evidence that is meant to grant the PR status. So that's one. And then I'll just quickly look at the chat. Rotate here, right? Okay, so this person says, I'm a physician and a PhD in global health sciences. So do I need an employer to be able to apply for permanent residency? So with cases like highly skilled professionals like physicians and PhDs, the short answer is basically yes for this. This sort of ties into perhaps a related note, which is that if you want to immigrate as a physician, then you have to get your medical credentials assessed by the Canadian Medical Council. That's sort of the stepping stone there. And then from there, if you have the appropriate licensure, then in some cases you could get a job offer with a province. This is rapidly changing. They announced some program in December, streamlining some of these processes. And I believe a few months before that, they streamlined the processes for US physicians so that I believe their credentials are recognized already. But if you're not a US physician, then there's some additional step that has to be done. And then you'd need a job offer. There were some amendments to the express entry system for physicians, just based on the fact that there were physicians who were working in Ontario, but the payment arrangement in Ontario was kind of an oddly hybrid system where some physicians were, in a sense, self-employed, but at the same time getting their remuneration completely from the government. So they just did not fit under the express entry structure system, which means you have to be in an employer-employee relationship to qualify under Canada Experience Class. So there were physicians who, although they were working in Canada, technically were self-employed and could not immigrate. So it was a perverse situation because we need physicians in Canada. So they made an amendment saying that if the physician is getting their remuneration from the province, even though it looks like they're self-employed, then they're basically deemed to be employed, and then they would have a pathway for permanent residency. So that would be the sort of only exception to this idea that, generally speaking, you need a job offer as a physician in Canada. So that's sort of the chat question. If there's any more questions, I'll just go back to the chat from time to time and do the ones that were posed to me by email. So this one relates to losing status while being in Canada. So this person was a visitor. Their status expired at the end of December 2025. And then they did not know that they had to file for an extension. And then what is the remedy if they want to stay? So the sort of fundamental aspect for this is that they can do what's called a restoration, but that can only be done if it is an application within 90 days of their loss of status, and they can only restore it to the status they previously had. So the easiest way to explain this is that if you were a visitor, then the status you had would be basically showing that you had enough funds to be a visitor and you had a new temporary purpose. It's not that difficult. It gets more complex. Let's say if you were a worker on let's say, a certain type of work permit, like a closed work permit. Closed work permit is when you're tied to one employer. In that situation, you could restore, but that you'd have to maintain that relationship with that previous employer. So the worst case scenario is that you were on a closed work permit, your status expired, and then you could not, if you no longer have a relationship with that employer, you could not restore your status to closed work permit with that employer because the term and condition of that work permit would not survive, because namely the term and condition would be that you have to be working for that employer. So if they let you go, you cannot restore your status to that employee on a closed work permit. In other words, this is all to say that you have to meet the initial requirements that were on your initial application or your initial status to go back to that status within 90 days. The other issue is, what are the consequences for that? So if you remain in Canada and you did not restore within 90 days, then at some point, an immigration officer can write an allegation under Section 44 saying that this person has entered Canada, no longer has status. And then if and when they find that out, they would interview you in person and say, you don't have status. They would issue an exclusion order to you. Then you'd be barred from entering Canada for 1 year from the date that you left Canada. So you don't want that, because what you may want to know also as well, that if there's a record that you were issued an exclusion order, that information is shared with the Five Eyes. That's basically the English-speaking countries: Australia, New Zealand, the UK, Canada, and the United States. So then if you want to visit those countries, and if you are asked on their applications, have you ever been denied something anywhere, you'd have to say yes. Otherwise, you'd be misrepresenting your status when seeking entry to those countries. So if I go back to the chat here, so this one says this goes back, I think, to the C11. So there's a picture framing business because the business owner is going to retire. And this is being done with a partner, and the partner will retire too. So if this business is bought, there will be employees. So would this be C11? So for this, the rubric I think to keep in mind is that if there are employees already existing in this business, and then if it is made clear that the viability of this business or the expansion of this business makes sense, and if in turn the expansion of this business necessitates maintaining or hiring additional employees, then this could be viable. I think to be safe, it might be good to have some kind of additional evidence, maybe in the form of a business plan that might posit the necessity for the existing employees and the long-term business viability of that venture in the locale where it's based. Because then the officer would say, okay, there looks like there's objective evidence that this business is viable and the employees will be maintained or expanded. So that's sort of the way to look at it for that. Then if I go back to the previous questions here, it says a Canadian citizen has a 25-year-old daughter, could not sponsor her for some reason. Okay, so this is kind of a fundamental aspect for the family class. So the family class has a definition of dependent child. Dependent child is somebody who is less than 22 years of age. So the norm is that a Canadian citizen or a Canadian permanent resident can sponsor their dependent child if at the time the sponsorship is submitted, the child is less than 22 years of age. So we call that the lock-in date. The lock-in date is when the application forms and the application fees are completed before age 22. Then the application is locked in. That means that the would-be child is not penalized if the processing time takes longer than a time in which the child may turn over the age of 22. But on the other hand, in this scenario, the child is 25 years old. So the narrow exception is that if the child is under some kind of physical or other disability that necessitates reliance on the parent, that would be the only way somebody over the age of 22 could be sponsored under the family class. But you would need corroborative evidence. So that would mean maybe psychological reports or specialist physician reports or things of that nature to say that this child is nevertheless a dependent child, despite not being the one in the traditional sense, i.e. under the age of 22. There's some, just for the sake of completeness, there's this last remaining family member category. So we call that the lonely Canadian category, which means if that Canadian citizen has no spouse or common law partner or no child or parent or any relative or uncle or niece or nephew in Canada, then they could sponsor one relative regardless of the relationship, but you have to have no relatives in Canada. I had this happen when there was one individual and he had no relatives, no spouse, and he wanted to sponsor his brother and his brother's wife and kids. And after some appeal, they recognized that he was truly a lonely Canadian. He had no relatives in Canada, and so he wanted to sponsor his brother or spouse and his, I guess, nephew and niece, to be precise. So that'd be the only other way, generally speaking. And I suppose there's the sort of unusual cases where maybe you're an uncle and um, your uncle or aunt and your sibling has a child and the sibling passed away, child is orphaned, then you could sponsor the orphaned child with proof of the passing of the parents of that child. So that's sort of more related to the family class as opposed to the stuff we've been preoccupied here. So for this, I'll look at again if there's anything in the chat and go back and forth because we're sort of getting closer to the amount of time allocated here. So let me look at questions here. Okay, this one might be pertinent for, I suppose, these digital nomads. And that's what comes to mind when I see this question. Can an applicant come and obtain a 6-month travel visa and then a work visa while there? Okay, no, that's sort of the same question. I sort of go back down. Oh, can they work while they're in Canada? Here. So the only way they could work in Canada is if they are not participating in the Canadian labor market. There's something called a business visitor visa, but in that case, you're usually talking with a branch of Canadian business that you might be affiliated with, or you're talking about your services, but you're not really participating in the Canadian labor market. So the closest thing I think that could be doing related to work is if your employer is outside of Canada. Think of, for example, an IT worker where their clientele allows them to work remotely because maybe they're working on software or maintaining software, and they could be in Canada while that's happening. But the sort of fundamentals there are that the remuneration, the salary is from, let's say, a US employer going into US bank account. So they're not servicing any Canadian um, labor need in Canada. So that would be the only way to deal with that. Then the other, excuse me, another question online from before. Can an applicant's son come on a travel/visitor visa and then get a student visa for college? So this depends on the age of the would-be study permit holder. So basically, a study permit holder can apply inside of Canada if they intend to study at the primary or secondary or middle school level. They're going to file for that inside of Canada. If you're wanting to file to get a study permit for post-secondary or college or university, then you must file it at an outside of Canada visa office. They don't really interview people anymore. I think that stopped maybe 15 years ago. But it's something to keep in mind is that because a study permit is a temporary application, you may make it a bit more complex if you're already in Canada. It's not fatal, but they would say, wait a second, you have less of a tie to your home country, and a study permit is a temporary application. Me as an officer, I have some doubts about whether you will return to your country of origin based on where you are submitting the study permit application. Again, it's not fatal, but you'd need to have a really robust application to justify the need to study. And maybe give some context about why you're applying for the study permit in Canada for this. So those are sort of the caveats and provisos for this. Take a quick look here. And then, oh yeah, because can I get a study permit and stay in Canada if you're 47 years old? So there are some cases, well, this is in the good old days, I'd say maybe 2021, 2022, where people litigated this at the federal court. And they were successful because in that case, the officer determined that the rationale given by that person, namely that I've been working in field X for this amount of years, I want to change my career. And the federal court judge said the officer erred in not considering that fact, because that's a phenomena that could happen. And if all the other things were in place, namely that the person had the funds to study, and they showed that this new career would be, after this course of study, viable in their country of origin, then the officer should have reconsidered this, and then it was set aside, and a new officer had to reassess it. So you have to sort of keep in mind the fundamentals of study permits for these sort of less common situations where the person is older than the norm of the aggregate of students who are entering Canada on study permits. And then sort of a basic question is, and if an applicant wants to further their education, and while they're in Canada on a student visa, can they still work on a student visa? The regime now, I mean, it's changed back and forth. It used to be 20 hours a week. Now I think a student can be on a study permit and work for 24 hours a week. And I think they can still work, yes, during their breaks, full time for this. My suspicion is this will change because in the 2025 November announcements, they were talking about reducing the amount of temporary residents. So it may revert back to how it was 15 years ago, when study permit holders could only get a job in more narrow circumstances, maybe related, ultimately graduating and getting a job only if the occupation is in demand for this. So that's something which is in flux, because immigration in Canada, like many countries, is highly politicized. So there's a lot of reaction to what the public is perceiving about things like infrastructure in Canada and effects by having more temporary residents in Canada, for example. And then, let's see, I'll look again here. Okay, no, okay, then previous question is, what are the options for an Indian citizen living in the USA on an H-1B visa as an IT professional to move to Canada with permanent residence? So for this, it all goes back to job offer. There was, in 2023, this sort of job grab by the Canadian government, where they were targeting H-1B workers specifically. If they had H-1B status, then they could not immigrate, but rather work in Canada. They were given a work permit. But this was, I suppose, tied to the labor market need at the time. So that was a very short-lived program. I think it ended in June 2023, and I think it filled up quickly. But now it's basically job offer based again for this. If you're lucky, maybe you work for a US branch, and maybe if they have a Canadian branch, and you could ask to be transferred to the Canadian branch and then enter on a closed work permit, and then hope that the extra 50 points will reemerge, assuming that the employer would want to keep you in Canada as an employee on a long-term basis. But again, that's a little bit speculative, right? And then sort of a more specific question related to the family class. What are the steps required to be sponsored by a spouse, and what are the financial amounts needed when beginning the sponsorship? So if it's a spouse with dependent children, then it's good to have a higher amount, because then there are dependent children. Strictly speaking, there's no financial requirement to sponsor a spouse, as long as it looks like you and or the spouse will not be on social assistance. So that typically means you're having some kind of job, or if you're a young person, you're studying and you will have a decent job that will not place you as a burden on the state, essentially, for this. So in other words, the financial requirements are pretty lax for sponsoring people as spouses, but they're a bit more tight if there are children involved, because then there's more of a burden. Still have a little bit of time. Take a quick peek here at the chat here. Okay, nothing. And then Let's see. Okay, apart from a post-graduation work permit, what options are available to a Russian student who has completed studies in Canada and is still in Canada, not yet gotten their PGWP, and fear returning to Russia due to war in Ukraine? And can they file a refugee claim? So the short answer is yes. The type of refugee claim this would be is refugee sur place, where there's an incident that took place while they were in Canada. In this case, it's this festering war since 2022 February. The sort of basics for a refugee are that you're a member of an identifiable group and you might be targeted, or maybe you're a conscientious objector and you don't want to serve in the war. And so you're saying that you have a belief, and that belief could cause you to be imprisoned or persecuted. So those are sort of the fundamentals. Or you're fearing of cruel and unusual punishment, in which case the requirement to be part of an identifiable group is not quite as amplified for that. And then there's also, aside from that, if your work permit expires, you can ask for a TRP. There are these niche programs for Iranian nationals and Ukraine nationals. There was one program for Gazans. They would let in a certain amount of people for a temporary time because of the instability in those areas. But these programs tend to fall off based on the stability, whether the condition becomes stable. So let's see, I'll take a quick look here. No chats, questions here. Maybe I'll try to get to one question or so here. And then, okay, so this person applied for a visitor record extension inside of Canada to extend their status in Canada. The previous one expired October 22nd. They have not yet gotten a response. They want to know if they are still legal in Canada and if their restoration date will be affected, right? So in this case, the short answer is yes. If your status is expiring October 22nd, but you filed for the extension October 18th, then as long as the extension included the forms and the fees, then they don't want to penalize you for the slowness in the processing of the visitor record extension. So they grant you what is known as maintained status. So while the application is pending, you're still allowed to be here. So there might be a windfall if they take an extra long time to look at your visitor record extension. And let's say it was weak, and then if it takes 6 months, then you would still have valid status until 6 months later. And if they refuse it, and you can apply, well, no, you can't apply for restoration again. There's some finality to that. If the restoration is refused, then you really should leave Canada within 30 days. Otherwise, there's that risk of the exclusion order, which means the 1-year ban, which is deleterious to have in your record, just because if you want to, immigrate somewhere, it doesn't look good. So maybe got a couple more. See if I can squeeze some here, right? So a father's visitor visa was refused last week. Okay, very terse question. Okay, so the short answer there is visitor visas. The climate for visitor visas is not very favorable these days because of the desire to reduce the amount of temporary residents. It's a bit prejudicial when you have one refusal. Some of these, many of these temporary resident applications are disposed of with the assistance of AI. In some cases, these days, if the visitor visa was refused, sometimes as a courtesy, they give the reasons for the refusal in the decision. If the reasons were revealed, if they are patently unreasonable on their face, you could submit a second application. Keep in mind, the AI is, I don't want to use a scientific term, so I'll just say the AI is a bit wonky. So in some cases, the AI, if it sees a refusal in the past, you could have the best visitor visa application the second time around, and it just might refuse in 2 days. This is anecdotal, but I've heard this more than 2 times. So if you're really enthusiastic about visiting Canada, you might end up with a wrongful refusal, the only remedy is really federal court. I mean, there's a secondary remedy we used to recommend, which is reconsideration, but there's no guarantee about reconsideration. So I think if you really, really wanted your father to visit Canada, and if it's a second refusal, you really must consider going to federal court, in which case you need a lawyer, such as the lawyers here. So we're kind of at time, so I want to say the plug here, which is this is Chaudhary Law Office. We have me and two other lawyers, and we do all of these kinds of cases, including the cases to get redress against refused cases, not just the processing of cases. So just for the sake of the chat, here's the website. And the intake email is clerk@chaudharylaw.com. And then you can Google us on the socials too, I suppose. And so I hope you have a good day as well. So this would conclude the webinar, and please feel free to reach out. Thanks again. Bye-bye.